Good morning. Do we have any?
Test 1, 2. Are you guys able to hear us?
Yep, that sounds good.
Good morning. And as chair, Senate Chair, I apologize for the delay. This is a meeting of the Criminal Justice and Public Safety Committee. Today is July 15th. On the agenda today, we have 3 items. LD 1890 is a bill regarding prisoner transport, followed by LD 2037, amend the criminal code, followed by 2139, an act regarding government accountability. I am Senator Susan DeChambeau, representing District 32 and co-chair of this committee. I will have my co-chair introduce herself, and then we will have the other members present introduce themselves also.
Thank you, Madam Chair. Good morning. I'm Representative Charlotte Warren, and I represent Hollowell, Manchester, and West Gardner in the House.
Representative Cooper.
Good morning. I'm Janice Cooper. I represent Yarmouth, Chesapeake Island, and Long Island.
I'm Mike Carpenter, Aroostook County, Senate District 2, Presque Isle to Patton.
Good morning. I'm Penny BB Center. I represent House District 93, the town of Owl's Head, in the city of Rockland.
Good morning. My name is Victoria Morales, and I represent a portion of South Portland in the House.
Good morning. I'm Ann Carney. I represent House District 30, which is part of Cape Elizabeth.
Thank you. I wish to welcome our newest member, Representative Carney. Nice to see you. Thank you. We have a few members who are on Zoom. If you wish to please, I would like to recognize, beginning with Representative Corey.
Good morning. I'm Representative Patrick Corey. I represent the good people of Wyndham, and I'm here in Wyndham today.
Lucky you. Representative Lois Rickett.
Yes, this is Lois Reckett, and I represent the ocean end of South Portland, and I'm in the ocean end of South Portland. Thank you.
Are there any other committee members here? Representative Johansson, are you with us? Okay. Thank you. I had asked previously if, because we have a small group, if we can remain in this room. Have we received a response? Apparently the response was to go to the other rooms. So I will ask that we take a 10-minute break. So the people who are assigned to another room would go to another room. I will get further clarification if you can come back and remain. Apparently it had to do with the presiding officers. Both presiding officers have to agree that you remain in this room. And for the public, that has to do with social distancing areas. So let's take a 10-minute break. If we can get a clarification that you can remain in this room, we will do that. We shall begin. I took the recess to confer as was required by Grant Penoya's office, our executive director here. The people who are currently here, 1, 2, 3, 4, 5, 6, 7, which is a quorum, and I think we can declare that we do have a quorum present. If you feel comfortable, and we are within 6 feet of each other, if any of you, however, you must wear your mask here. If you have breathing problems or you do not wish to wear your mask, you may go to another room and we will recognize you. So if everybody's set with where they are, we can remain here. All right? So first thing on the agenda is 1890. The title of that bill is an act to improve prisoner transport safety by specifically authorizing transport of prisoners by transport officers. And this is sponsored by Representative Farnsworth, who I see is with us today. I will turn it over to our policy analyst to go over, this is a work session. So is it Ms. Sedgwick or Ms. Overton?
I'm here. Okay, can you hear me okay? This is LD 1890, the Act to Improve Prisoner Transport Safety, sponsored by Representative Farnsworth. The bill was heard. There is a, members have a packet for today's 3 bills. It has all 3 bills on it. It's also been posted on the committee website under documents. This bill was heard January 1 and worked on March 4th. It was scheduled for work session March 16th, and that was canceled. Representative Farnsworth prepared an amendment dated March 14th. It was ready for you for March 16, but obviously it was not presented. It is included in here in the packet. So what you have in the packet is a copy of the bill and then a copy of the proposed amendment from Representative Farnsworth. You will see in section A10 of the proposed amendment a disagreement between Representative Farnsworth and NAMI Maine, represented by Jenna Maynard, with regard to the training for law enforcement, the law enforcement training for the transport officers. Since that was prepared, you'll see further on in your packet an email from Anna Black that tells you that they resolved that issue, that she recites a meeting that was held, I think it was on Monday. Danny Spence was there, Jenna Maynard, Corey Swope, Rick Desjardins, who is, welcome Rick, he's the new either director or acting director of the Maine Criminal Justice Academy. Diane Sleek, Sheriff Joyce, Representative Farnsworth, Commissioner Liberty, Bob Reed, who's a NAMI board member, and Anna Black. And on the back side of that page is the proposal from them working out that proposal, the disagreement in section A10. So that appears to be worked out amongst them for presentation to the committee. I don't know what other issues there are outstanding. I wouldn't want to say that there aren't any, but I'm just not sure. That's all I have.
Any clarification from the committee? Any questions of Ms. Overton?
Thank you, Madam Chair. Ms. Overton, I am just looking at is it in our yellow packet where the email from Anna Black is?
Yes.
Okay. And this was particularly, do you know what the discussion at the meeting was about, the context of the discussion at the meeting?
No, the only thing I know is that is what was reported in the email and the proposal on the backside. A number of people who were there are on the email today.
Okay.
And so if you wanted to hear from any of them, you could ask them.
Okay, thank you.
After we had a public hearing, correct me if I'm wrong, Ms. Overton, there was a meeting between the agency of an organization of NAMI and the sheriff. And following that, there's been a recent meeting. So are we looking at the amendment from the recent meeting that included a greater number of individuals, including Commissioners Liberty and Sawchuck and some other sheriffs? So is that the amendment we're looking at now that came out of that meeting?
If you go through the packet to the email from Anna Black to me, dated Monday, July 13th, that is the day that they had that meeting. That meeting was pretty representative of interested parties, and the agreement is on the back side of that. The agreement starts with amend Title 25, Section 2803-A, subsection 8-C. So that's very recent. It was Monday of this week.
Was the agreement unanimous?
I wasn't there, but everybody who was there, almost everybody who was there is on this Zoom call.
To recognize Representative Morales.
Thank you, Madam Chair. Just a quick clarifying question around the definition of a transport officer. Is it still the case that a transport officer is not a law enforcement officer?
Can someone answer that question? There are people on Zoom that were at that meeting. The question is a transport officer not a law enforcement officer, although the amendment does say it's a law enforcement.
They're not certified by the BLEPI. They don't go through the BLEPI. They're not a certified police officer.
Okay, thank you.
Corrections officer.
That is correct.
They are not law enforcement officers, certified.
They are not law enforcement officers in most cases. That is correct. Some counties use them as an adjunct to law enforcement as a part-time police officer in other duties, but they're not law enforcement officers when they're doing transports.
Okay. Thank you.
I have a question probably of Sheriff Joyce or any sheriff that's there. In the proposed amendment, it says the pre-service, in other words, for certification, the program must include pre-service law enforcement training. I believe I'm correct. That's the 2-week training, is it?
Yes.
That reserve officers take.
Yes.
Currently, Sheriff, correctional officers are doing the transport. Do all correctional officers currently receive the 2 weeks pre-service law enforcement training?
No, only if they want to be considered as a transport officer. So when anyone works as a corrections officer, they get the 6 weeks training through the MCJA, and then they come back and they work in the jail. If they want to be considered to do the function of transport officer, then they have to take the law enforcement pre-service and go through that. Then they can be considered a transport officer.
I guess it begs the question, therefore, for me. Briefly, what does the 2-week training entail that the others don't have to have?
Well, and I may defer to the academy if the academy's on, but basically what an individual is getting in that, and it's actually, I think it's over 5 weeks now. There's a 40-hour online, then there's a 2-week in class, and then either a 2-week or a 3-week on the job training type thing. So basically what you're getting out of that is the basic training to become a part-time police officer. Yeah, so you go over domestic violence, de-escalation, firearms, constitutional law, state law, those type of things.
Thank you. If anybody wanted to add to that the sheriff failed to mention, thank you. Representative Warren.
Thank you, Madam Chair. From where I'm sitting, part of what's problematic of this bill for me is it is authorizing deadly force of folks that aren't even trained as full law enforcement officers. I can't support this proposal. I move ought not to pass.
It's been moved and seconded, ought not to pass. No further comments on that. Senator Carpenter, you would like to know where that's referenced? Representative Warren.
I see it now.
5C, officer responsible for custody pursuant as a result of arrest is justified in using deadly force. It's mentioned a few times, but for self-defense, to prevent an escape from custody.
So a follow-up question, at least 5C large A is, and a hybrid version of B is the standard definition of when anybody can use deadly force, correct? Am I wrong? I'm authorized to use deadly force if for self-defense or to defend a third person when I believe that I'm about to be faced with the imminent use of unlawful deadly force. Correct? I'd have to go look at 17A, but maybe.
Representative Morales.
Yes, thank you, Madam Chair. I don't read it that way as deadly. We are authorized to use force on another person if they're using that force on us, but I don't read A to say deadly force on the officer. Could be on anybody in their subjective opinion.
If I may, that motion was made after the statement of deadly force. If we need a clarification on use of deadly force, I think we need to be clear on that and not just the words. is there anyone who wishes, that has experience in that, to discuss why that term use of deadly force is in this, on transport officers? Sheriff Joyce, did you wish to make a comment or
Yes.
response?
Yes. So currently I have 10 people that are responsible for transporting inmates throughout the county, throughout the state. They're corrections officers. Now, keep in mind, corrections officers, when you're certified, that certification allows them to use deadly or non-deadly force in the function of their job inside the walls of the jail. However, when those transport officers who are correction certified and only have the law enforcement pre-service leave the jail, under the transport definition, there's no authority. So I've had to make them commissioned deputies, which in essence makes them a part-time police officer in order to have the authority to defend themselves or somebody else outside the perimeter of the jail, whether it's at a court, whether it's doctor's office, whether it's on the turnpike. The problem is the transport officer definition back in 2004 was created because the transport officers aren't police officers. So we're commissioning them to be police officers so they have the authority, but they're not police officers. And if you take it a step further, by having them considered police officers in order to have the authority outside the jail, and they work more than 1,040 hours, then currently I am violating the spirit of the law that basically says if you work more than 1,040 hours as a police officer, then they must go to the Maine Criminal Justice 18-week academy. That would be hugely cost prohibitive for me to send all 10 people to the academy when all they're doing is moving inmates from point A to point B. But they have to have the authority, because if there's an escape attempt or somebody comes at them, once they've left the facility, if we call them transport officers and take away the designation of law enforcement, which is what we're trying to do, they will not have any authority to defend themselves or a third party. Hopefully I've not confused people.
I would like to follow that up with Commissioner Liberty. If you're available, the Department of Corrections oversees the standards in jails. If what Sheriff Joyce said about Cumberland, is that also true with the use of deadly force with other sheriffs and with the Department of Corrections?
Yes, I think that what Sheriff Joyce indicates is absolutely true. Maine Department of Corrections uses corrections officers that are armed, and their training is enhanced. They get weapons training and use of force training and beyond the basic corrections course. But I think that you'll find that the majority of the county jails and MDOC use corrections officers that are armed. Some, very few, are unarmed with some of the jails, but that's currently the practice. And I think some of the challenge that Sheriff Joyce has is that he's nationally accredited, and that's very commendable. And but I would say that the majority of us are using armed corrections officers to transport those offenders.
I would recognize Representative Corey.
Thank you, Madam Chair. Just so I have this right, and this is sort of my basic understanding of how this works. So you can basically sort of become a police officer for, I believe, a year with that sort of pre-training. And then once it goes beyond a year, then you have to go through the BLEPI program. For me, this seems, reasonable, for these transport officers to have undergone, that kind of training, because I believe that those officers that have gone through that pre-service training, they're allowed to use deadly force in defense of themselves or in defense of another, like, Sheriff Joyce was just saying. I just want to make sure I have that correct. Can somebody just let me know if that pre-service training is number one. What allows somebody to become an officer, prior to going through that other 18-week course. And, number two, that people within that pre-service training are allowed to use deadly force in defense of themselves or in defense of another. Good, thanks.
So I guess I'll
Commissioner
respond.
Liberty, you had your hand up. You wish
Yes,
to
I
make
would
a
just say
comment?
that, yes, I would just say that it's not, it's those officers that do the pre-service course, they can work up to 1,040 hours per year. They can have a whole career of part-time service, working less than 1,040 for their whole career if they do it on a part-time basis. Those individuals that are reserve officers or just work less than 1,040 hours, they are authorized use of force as indicated in this proposal. So it's not something that's specific only to transport officers. It's all part-time law enforcement officers that are only certified through the pre-service course.
Right. Before I call for a vote, anybody else wish to make a comment or clarification? Seeing none, would you please repeat the motion?
Thank you, Madam Chair. I made a motion ought not to pass.
Are we calling a roll call? Or?
So we'll give folks a couple minutes who aren't in the room, if you're in other rooms, to come in the room to vote. And then, unless everybody that's in the building is already in this room, Deb, they are, okay. And the clerk will call the roll.
Representative Cooper.
No.
Representative Cooper, no. Representative Beebe Center.
Yes.
Representative Beebe Center, yes. Representative Warren.
Yes.
Representative Warren, yes. Senator DeChambeau.
No.
Senator DeChambeau, no. Senator Carpenter.
No.
Senator Carpenter, no. Representative Carney.
Yes.
Representative Carney, yes. Representative Morales.
Yes.
Representative Morales, yes.
Just letting folks that are committee members know, if you're not in the room, the same rules apply of lodging your votes with the presiding officers. So just to let folks know that.
Okay. Thank you. Moving right along, the other item on our agenda is LD 2037, an act to amend the criminal code. Ms. Overton, would you wish to, could you?
Could I have a
We
point
gotta
of order
hear-
before we launch into this one?
I'm sorry, I didn't pick up on that.
I said I have a question before we launch into the next. I understand that Patrick and I can vote with the presiding officers. What about the other committee members who didn't happen to be here? Are they also eligible to vote in that way?
I believe so. Yes, they're members of, that happens all the time. They'll be able to look at this or and vote. I'm saying yes, no different than what we would have done if we were all together and you were away on vacation or the hospital, you can still vote.
Right.
Okay.
I just wanted to clarify that. Thank you.
Well, I've been known to be wrong sometimes, so. Yes, Ms. Orbiton, as we would normally, an act to amend the criminal code. We had a public hearing on that. Do you wish to make any comments on that or presentation?
Well, yes, this bill was, going back to the packet of information that you have. It was heard February 28th. It was scheduled for work session March 16th, so it also was delayed. At the public hearing, CLAC proposed a committee amendment to correct a drafting error with regard to the effective dates for the sex offender registry and repeal a section of law on sexual assault on factors aiding in predicting high-risk sex offenders for sentencing purposes. Attorney Michael, is it Kabidi? I apologize if I have mispronounced. Representing the ACLU testified against the repeal of the section 1609 and its verbatim reenactment in 1609 section 1. And he offered to bring to the committee a proposed amendment to give the judge a discretion in sentencing with regard to concurrent or non-concurrent sentencing. In your packet, you have the bill, the proposed amendment from CLAC, which was presented at the public hearing, letters from the Sex Offender Management and Risk Assessment Advisory Commission indicating opposition to Part E of the bill, and then another letter retracting that opposition, and the bill analysis form dated March 12th. Those are all in your packet. So since the work session, since the public hearing that you had on it, I think the only change was the withdrawal from the Sex Offender Management and Risk Assessment Advisory Commission of their opposition. And then we were also hoping to get something from the ACLU with a proposed amendment giving the judge discretion. That's all I have.
Okay. Excuse me, I missed the last part. Ms. Orbiton, did you say we have an amendment from the ACLU?
I don't have anything.
Okay. I think their testimony, okay. Representative Warren?
Thank you, Madam Chair. A couple of things on my part before I make any motion on this, but I do agree, and I think that we did have a lot of conversation about this, of removing the first section, Part A, which had to do with, I'm sorry, and it may just be Section A1, I guess, about this idea of mandatory non-concurrent sentencing. In my mind, and I think from the folks who testified in front of our committee, this is sort of a back step. It seems that the way we've been moving is trying to eliminate mandatory sentencing. This bill, this first part, excuse me, just the first part, is a return in some ways, but it is a mandatory non-concurrent sentence. So it's tying the hands of the judge, which I think we heard testimony about. And so when we get ready to deal with this bill, I would like to amend to move that out. But I put that on the floor for discussion.
So that's Part A, number 1, that whole paragraph?
Yes, Madam Chair.
Mr. Pelletier, where? Do you wish to speak, Mr. Pelletier? I can't find you on the screen.
I do.
Okay, oh, there you are. Go ahead.
I'll only point out that in Part A, what's labeled 1609, subsection 1, through there's two portions through the line and a half at the bottom of that section. That is existing law. So I just wanted the committee to know that.
I want you to repeat that one more time. What's in the existing law, please?
In Part A, Section A1, you have 1609 appears all underlined as Section 1 and Section 2. Section 1, the first part referred to by Representative Warren, is existing law and it's of long standing.
Pelletier. I'd recognize Senator Carpenter.
Then why does it appear in here as new language?
You respond to that?
Jane will correct me if I'm wrong, but it's a drafting convention required by the revisor's office. I think it's given the scope of my understanding is given the scope of the amendment, which adds number 2, the required convention was to repeal and replace the section in total.
Senator Carpenter.
I noticed, I think Mr. Kabidi wants to say something. Either that or he was waving to me, I'm not sure.
Mr. Kabidi.
Senator Carpenter, it is good to see you. I both wanted to speak and wave to you. Senator DeChambeau, thank you for calling on me. Representative Warren, members of the committee.
Mr. Kabidi, I hope you identify yourself for the public.
I will. My name is Michael Kabeda, and I am policy counsel for the ACLU of Maine. This issue was brought up and discussed at the public hearing. Section 1609 is existing law. And at the public hearing, Representative Cooper asked us, the ACLU, to bring an amendment to address the problem created by existing law. The problem, as earlier touched on by Representative Warren, is that judges' hands are tied when they decide whether to charge someone who's serving a sentence with a new crime. The way judges' hands are tied is they are forced to sentence someone to a new term if they pick up a charge while they're in prison. They're forced to extend that person's sentence. They don't have the option of ordering that the sentence be served at the same time as their existing sentence. And we think that that's an unfair restraint placed on judges. One quick story, which I told at the public hearing, might help put things in better perspective. I know I prefer stories to reading law. If you're in a cafeteria in a prison, a fight breaks out, you become embroiled in it, and that leads to you being charged with assault and battery. The judge looks carefully at all the facts and decides that you were not the instigator of the fight, but that you should still pay for being involved in that fight, but you shouldn't pay with a longer sentence. You should only pay with a new charge. The new sentence that this new charge creates, you should serve at the same time as your existing prison sentence. Well, judges right now don't have that power. Judges are forced to extend your sentence or give you no sentence at all. And we think that judicial independence is important, that judges are the people closest to the facts, and that they should be the ones to decide whether sentences are concurrent and non-concurrent. That decision should not be made for judges by the legislature. And so I do think that the amendment my colleague Megan Sway, who's also policy counsel for the ACLU of Maine, sent in an email, I believe it was yesterday, suggesting a repeal of Section 1609 does that. It restores judicial independence and lets the people closest to the facts make the determination whether the sentence should be concurrent or non-concurrent. And that's it. Thank you.
Representative Morales?
Thank you, Madam Chair. So I have a question just around reading, and maybe Mr. Cabetta, if you could respond to this, but what we have in front of us is 1609, 1 and 2. And if we were to leave them together, I'm not sure how they work together. Do you have any comments on that? It seems like one cancels the other.
Anybody wish to respond to that?
No, but I have another question that's related to it, if I could.
Yes, if we don't have anybody answering that question. Please, Representative Carney, you.
I had that same question and I've been looking at it and I'm not 100% sure that this is the difference, but I believe it might be, is that Section 1 is an allegation of a crime that occurs during the execution of a term of imprisonment, whereas Section 2 is during the stay of an execution of a term of imprisonment. And I'd just like some clarification if that is indeed the difference.
Jane raising her hand.
Representative Rickett, can I go to Ms. Orbiton, or do you wish, is there a comment you want to make, Jermaine, to what we just talked about? Okay. Ms. Orbiton, please.
Yeah, I'm sorry. I believe John Pelletier had his hand up to respond to that question.
Mr. Pelletier, I'll recognize you. You had your hand up.
All right. Well, Representative Carney accurately described the distinction between the two sections. So the existing law applies to an offense committed while in execution of a sentence. And number 2, the new language applies to an offense committed under various circumstances that involve a stay of execution.
Thank you.
Any other concerns about this bill? Representative Rickett, go right ahead.
Yeah, I'm trying to figure out whether what we really want is to eliminate Section 1A. I mean, what is it that it brings to the table that isn't currently the case, or that mucks up discretion or doesn't? I mean, I can understand the deletion of the mandatory piece. I'm in agreement with it. But the discretionary piece, it seems to me, is a very finite kind of piece that seems somewhat related to the other one. And it just doesn't make sense to me to just have 1A2 without anything else. So I don't know. Somebody convinced me I'm crazy, which won't take long today.
Jane, you wish to answer?
Well, I can't. I don't want to answer the question, but there is the bill suggests in Part A repealing 1609 on mandatory concurrent sentences. That's in subsection 1 now in the bill. and adding a new discretionary, non-concurrent sentence in subsection 2. If you need to decide what you want to do. If you want to repeal the current law on non-concurrent sentences, you need to repeal 1609. You can't just take Part A out of the bill because it won't repeal 1609 if you do that. So you need to decide what you want to do with regard to non-concurrent and concurrent sentencing. And I have a question for Mr. Pelletier, which is, if the committee decides that they don't like Part A and they want to repeal 1609, does that leave the judge with discretion, or does that leave a hole in the authority of the judge to sentence with regard to these situations?
I'll answer if I'm recognized.
Yes, Mr. Pelletier, go ahead.
Okay. So you'll see if you look at the section that both 1 and 2 begin with the words notwithstanding section 1608. Section 1608 is a section that governs when you have more than one sentence, do they run together or do they run consecutively? And there's some other things that govern when you have more than one sentence. So if Jane is correct that this is a repeal and replace section. So if what Representative Warren suggests doing were to be done, you would simply repeal 1609. And then the question of how to manage sentences for a crime that occurred while a person was in execution of another sentence, or a crime that occurred while the person had one conviction and was on stay of execution, that would all fall back to be governed under the general rules of section 1608. So there would not be a hole. Section 1608 sets out the general rules of how a judge decides between a concurrent and a non-concurrent sentence. Current law makes a special case out of the situation when the crime occurs during execution of a sentence. If you repeal that special case, then both that special case and the other special case identified in this proposal of during a stay of execution, those would no longer be special cases, and they would be governed under the general law, which provides discretion to courts in certain circumstances to make sentences consecutive, but it does provide that concurrent sentencing is basically the default. You need special circumstances to justify consecutive sentencing.
Mr. Pelletier, could you, I'm curious, this is really a CLAC bill, the Criminal Law Advisory Commission. What was could you share with us why this is needed? What was the problem? What was the issue?
The issue was that I'm trying to recall, but the issue was that if someone committed a crime while they were on a stay of execution of the sentence, when that crime would be charged and processed in the ordinary fashion. By the time that crime, there was a determination on that crime, the person would be in execution of the original sentence. And there was there was no authority for the court to make the second sentence consecutive. Well, okay, now I'm remembering it. You can't have a sentence of imprisonment consecutive to a sentence that involves probation. So most sentences involve probation. So the person gets a stay, they go out, they commit a new crime. By the time the new crime's adjudicated, they're in execution of the first sentence. Let's say the judge wants to give them an extra 30 days for the sentence, for the crime that happened while they were on the stay. But their sentence involves probation. You can't make a sentence of 30 days in jail consecutive to a probated sentence. So what this does is it authorizes the court to say, after I sentenced you to this first sentence, you committed a crime. Now you're in execution of that first sentence. We're going to stop the counting of those days. We're going to insert 30 new days. And after you serve the 30 new days, we'll allow you to begin serving that sentence again. So thank you for that explanation, because now that I've thought about it, it is simply not repealing all of Section A1 would not solve the problem that Clark was aiming at. If you want judges to have the discretion to add that extra 30 days for the crime committed, then you would want to keep 2. Because under current law, in the scenario I just described, there's no authority to give the person who has a probation at the end of their sentence the extra 30 days that I described.
Thank you
So
for
you
that
could-
explanation. That's pretty much, to be very a layperson explaining it, you are correct. You know, someone could be serving a 5 years, all but 3 years suspended and probation, and during that 3 years commit a crime of trafficking in drugs. The judge would give them a year or 2, and they would state it is non-concurrent. Therefore, in the middle of their serving their sentence, that stops so they can serve that other sentence. Then it resumes. Pretty much that the non-concurrent sentencing. Representative Morales.
Thank you, Madam Chair. I'm not remembering from the hearing any kind of testimony we had on the situation, like the data on how often this is happening. Do we have that in our packet, that there was sort of the justification for why this is necessary to be able to add that?
As far as if you look at the packet, I was curious how many people did testify. ACLU did a great job also, and they had some problems with it. But interestingly enough, the Maine Association of Criminal Defense Lawyers supported the bill.
Only with removing that section.
Yeah.
Just to correct that, the Maine Association of Criminal Defense Lawyers supports the bill with the removal of that section we're talking about.
You would assume that, yes. True. I know it's kind of difficult for us to go back in March and even before then when we had this hearing, but I'd like to know if we can continue or.
Could I ask for clarification?
Representative Reckitt?
I need a clarification of what the motion is that's on the floor is. Is it to?
There is no motion.
Oh, I thought, okay. So it's the suggestion that I heard was deleting the mandatory piece. But does that mean that one could, it sounds now like you could in fact delete 1609.1 and not 1601.2. Is that true?
Representative Warren?
Thank you, Madam Chair. Excuse me for trying to do a bunch of things at once here. But I wanted us to have the opportunity to talk about this bill, obviously, and the pieces about this bill, but I didn't make a motion earlier. I do think that there are a couple things we need to decide on when we get to voting on this bill. And one of them is, do we repeal that section and also, I mean, take it out of this bill in order to pass it? And also, are we as a committee interested in repealing section 1609? Sounds like some of us are, I'm not sure, but that's a discussion we need to have at some point. But also, and again, apologies for adding this in, also there's another issue that many of us have spoken about. I spoke to some folks this morning as well, which is sort of lingering out there, and that has to do with the MIAC or the fusion centers, the main information analysis center or the fusion centers. And as we all know, a CLAC bill is a bill that often contains many different things. As you see here, it's got a bunch of different pieces to it that aren't connected. It's sometimes seen as a cleanup or a way to deal with some issues that are outstanding. To me, in my view, the only vehicle we have left as the Criminal Justice Committee to have any oversight or to ask for any oversight even, and again, I want to say that, to ask for any oversight into the Fusion Center is through this vehicle. I did spend some time on the phone yesterday with folks representing the Fusion Center. As you all know, I hope you've gotten the email. We will send it around again. We have been invited to join the Fusion Center's advisory board meeting tomorrow at 2. They have offered to then answer more questions after, if that's something we'd like to do. It's an opportunity to get more information. I have spoken a lot, so I am not going to make a motion to table, but I would sure appreciate if we could give ourselves a little more time with this bill, possibly table it to Monday when we already are meeting and already have other bills, so that there is still a vehicle left for us to possibly ask for something from MIAC when we come back in January. I think we'd have to do some work together before Monday and decide what we want. I think I've heard certainly from a lot of Maine people. We've had the 3 major newspapers editorialize that MIAC should have better oversight. And I'll stop there and see what my colleagues would like to do. Thank you.
Well, I would like to respond to that also. I'm hearing a couple of things to possibly table this or work this bill, but also the question about MIAC. And I thank you, Representative Warren, for reaching out about attending the meeting tomorrow as guests or as anyone could. As far as MIAC, I think I heard the word amendment, and to say that this could be an amendment to a CLAC bill, yes, no, what have you. But I also heard we could get ideas for come January. So those are 2 different things. I would suggest to all of us that procedurally we do have bills that we've worked on in public hearings. This is the purpose of these work sessions, to move this forward for if and when we do meet as a full committee. I also have concerns about MIAC. It's a unit. As I don't know if in 4 days we'll be able to decipher the difference of what really is, what is on paper and what is on the front page of newspapers. Also, come January, we have a new committee. So I'm not sure if MIAC right now is germane to our discussion. Is it considered very important, questionable? There are a lot of questions. And before we could entertain an amendment, I would presume we would have a public hearing for people who wish to talk about MIAC, either in favor or in opposition to MIAC once we have it. I cannot imagine that we would have an amendment at this stage of the game on any other subject that would have an impact. And MIAC does have an impact to 162 police chiefs who depend on that, and also 15 sheriffs, not counting Marine Patrol or game wardens or forest rangers who depend on MIAC. All those individuals should have an opportunity to discuss this, and it does not just rest with us, given the only information that we have is what we read in the newspaper. I think it's important, and it's important that we take deliberate action come next session, and we can gather information. But as far as putting it into a current bill that we have just had a hearing on, is not germane to what we should be doing. Any amendment, if we had an amendment that impacted poor people, indigenous people, or what have you, we should not vote on that until we let those individuals speak at a public hearing. So I'm opposed to anything being added having to do with MIAC to this bill for those reasons. And most definitely, this chair of this committee, if I sit here in January, we will look at MIAC. Representative Bibi Center.
Thank you, Madam Chair. I think the MIAC discussion is a very important discussion. I think the timing of it is very important. And I would like to give us a few more days to make that decision, whether we're going to use this as a tool or not. So I'm asking that we table this until Monday, and that we
Representative Corey, I'm sorry, I didn't have my mic on. Representative Bibi Center was going to make a motion to table. I've asked that I recognize you. You had your hand up if you wish to speak before I go back to Representative.
Yep. So even if we were to put together an amendment as a committee, I think that we could still have a public hearing on that amendment if it was something that we wanted to do. So I don't really feel the need to sort of push this off until next session to do it. So if somebody wants to make a tabling motion, it's not that, even if we put amendment on this, we don't necessarily have to do that without having a public hearing in the future. So if Representative Bibi Center is going to make a tabling motion, I'll certainly support that motion. Thank you.
And remember, the presiding officers have a say in this also, but Representative Bibi Center, your motion, please.
I'd like to make a motion that we table this until Monday.
Okay. What we're tabling is this bill. Okay. So tabling motion to do more study for Monday. Yep. I'll just ask if all in favor. If you don't want to do a roll call, you want to do a roll call? Okay, all those in favor? Okay. Unanimous for tabling.
Madam Chair, I have a bill that's happening in HHS right now, and the next bill you guys have is also my bill. So if I'll go deal with my bill in HHS, and if you guys have questions, could you wait for me to come back? I'm sure you guys could start it without me if that's great.
Well, I may have another suggestion. It's 11:35. And, okay, well, I would throw it up to the committee members. We can take a break till, and I'm concerned about the public too. I want to be able to tell them when we would be back. So if you are, they could be in the middle of another bill, so that's what I'm wondering. Okay. I don't think that this bill in front of you guys is going to take very long. Anybody have any concerns? Would you wish to take a half-hour break and wait for, you wish to go on?
Hey, Senator, this is Jane.
Yes.
I have a question of something that I didn't do this on the first bill that I just want to make sure you know that we skipped a step. And that was on the first bill, which was 1890 on prisoner transport. The majority vote was ought not to pass. That was a majority of 4. We didn't get an explanation from the three people who voted no on that, who must favor something about the bill. We didn't get an explanation of what they want. And we should have done that.
So you want an explanation from the people who voted? The motion was on not to pass. The 3 that voted, and I believe it was Representative Cooper, Senator Carpenter, and myself, who voted
Yes.
no on not to pass.
Right. So do you favor ought to pass as amended with the amendments that were presented to you today?
Correct. For me.
Same for me.
All right. Yes.
Yes. Okay.
Thank you.
Thank you.
So we will proceed with LD 2139, an act to increase government accountability. Pretty good
All right.
title.
You ready?
Yep.
This is Representative Warren's bill, LD 2139. The bill was heard March 13th and a work session was scheduled for March 18. Obviously, that did not happen. So what you have, it's at the end of the packet. You could probably go to the end of the packet and then, come back towards the front. What you have is a copy of the bill, the Intelligence and Investigative Record Information Act, which is Title 16, Chapter 9, the testimony from Representative Warren, a fact sheet from the ACLU of Maine, testimony from Attorney Nathan Freed Wessler of the ACLU, testimony from Major Groton of the Maine State Police, and a bill analysis from July 13th. That was Monday. In addition, on, I think, I'm going to lose track. The days all go together these days. I think it was this morning. Is that right, Major Groton? Well, you nod your head yes. This morning you got a proposed amendment for this bill from Major Groton, and it's been posted online and it was sent to you in an email this morning. In addition, I think you may have a paper copy. I think it got here in time so that paper copies made it into your file. So what you might want to do is take a minute to think about what the bill does, and then have Major Groton talk to you about his proposal.
Thank you. I think, yes, I'd like a moment to read this. Do you have it? Okay.
I mean, if I may, the bill is pretty straightforward. I think probably Major Groton can explain to you exactly what the bill proposes and the difference between the bill and his proposal to you. And I know he was hoping to talk with the ACLU, so I don't know whether the proposed amendment reflects some negotiation and discussions between them, or whether it's just from him. So you really need to hear from Major Groton.
Thank you, Ms. Overton. I agree with you. Representative Warren did mention that she spoke with Major Groton, and so yes, welcome, Major Groton. If you could just, if this is a result of your discussion and if the sponsor is supportive of the amendment, go right ahead.
Good morning. Thank you, Senator. I did have a chance to have a conversation with Representative Warren yesterday, although she's not seen the amendment because there was drafting going on and some email exchanges between our staff attorney who drafted this and the ACLU. So she has not seen this in writing that I'm aware of, but we did discuss it, so she's familiar with the content. We had some discussions in a Zoom meeting yesterday with the ACLU and as well as Nate Dressler, who was very helpful, very productive discussion. We talked about this and essentially where we are at, just to lay the groundwork, is that we are comfortable with the bill as it's written. We understand that. We're fine with this. As you probably remember from the hearing, Section 804 provides a number of circumstances where a GLOMAR response or the lack of releasing information under certain circumstances will still be appropriate. What we are suggesting in this amendment is that we take those elements and include this within 807A, which would be a new subsection to do. This would accomplish a couple of things. It would sort of codify and explain for the reader in the future the circumstances under which that information cannot be released. So we in the ACLU, and again, I would certainly not purport to speak for them, but my understanding of our conversation with Megan Sway and with Nate Dressler is that we all agree that there are still going to be circumstances under which information cannot be released by statute. That's set forth in federal case law. It's set forth in Maine statute under 804. So we know that there will be those circumstances. Passing this bill, what that accomplishes is that it eliminates the prohibition against releasing that information. So we're all fine with passing the bill as it's written, but this 807A recommended amendment would codify the circumstances under which that information may not be released. What we think this does is it establishes a rubric that everybody can read and understand. So when our response in the future is that, I'm sorry, we can't release this because it involves confidential information protected by statute, that folks can read the statute, they can read this new language, they understand why we're saying this. So this would provide a rubric for our decision-making that folks can easily find. What we don't want is to provide that response, which we all agree would be appropriate under certain limited circumstances, and to have the reader or certainly this committee feel like we're not making an appropriate decision, or we're not being clear with folks. We wanted everyone to clearly understand there will be times that we cannot release information. And this would set that out in statute. It would make it clear, and the reader would certainly understand why we're saying that. The second thing that this amendment would do, it would provide a clear appeal process for a person who disagrees with that decision. So we've worked with the ACLU on this. I believe we agree on the language, although I'm not sure that they agree that the language is necessary. From our perspective, we feel that it would be helpful because it would help the reader understand and provide clarity of 804 and federal case law so that the reader is not confused when they get that response from us in the future. So happy to take any questions that you may have about the reason for this, but again, we're fine with eliminating 807, but our concern is that we don't want anyone to feel like we're being misleading. We want to make sure we're being very transparent and clear, and when we do in the future have to use that language to protect somebody's privacy interests or security plans, those sorts of things, we want to make sure that that the public understands why.
Thank you, Major Groton. Representative Morales?
Thank you, Madam Chair. Major Groton, I think I understand what you said was that you are in agreement with passing the bill as written by the sponsor, but you've also submitted this amendment for clarity that you would like to add. And so my question is around, is that correct, first of all?
Yes, it is.
Okay, thank you. And then around the amendment, and I'm just pulling up the Freedom of Access Act in Title I, because I always understood that if a records request was going to impact an investigation, that was an exception to Maine's Freedom of Access Act already, and that there is an appeal process through Title I. And so I'm just wondering, how do these two, why can't we just go with that, and why the need for the clarification?
Well, that's correct regarding those records, but it's also important to look at Title 16, 804, and that sets forth certain circumstances which we're essentially codifying here, under which information cannot be released. A confidential informant, security plans. If we were to establish a security plan for legislators, for example, because of a threat, this would allow us to keep that information confidential. So there are certain circumstances, and simply what we're doing is taking that language and also reflecting federal case law that really came from Nate Dressler, and we're codifying that and putting this into this new 807A, so that if our response is, I'm sorry, we can't release that, it's statutorily protected information, folks will clearly understand the rubric that we're using for our decision making.
Okay, thank you. And I couldn't quickly pull up the appeal process, but is it a different appeal process under this proposed amendment for 807 than it is for the Freedom of Access Act?
I'd have to go back and do some analysis to really compare the two side by side. What we've done is to again, working with the ACLU to set forth a process where somebody can fairly efficiently and quickly, when times are normal, they can quickly and efficiently appeal this and get a decision. So that we wanted to create and clarify that there is a specific appeals process available to somebody who receives a response that we're not going to release information. So we think that helps make this clear. I think by putting this all in one section, it allows the reader to quickly understand why they're getting this response from law enforcement and what can I do about it, versus having to look through different places in statute, research case law to understand that decision and their options.
I see. I see that Megan Sway had raised her hand, maybe to respond.
You're all set, Major Groton. Finish with your statement.
Thank you.
Megan Sway?
Yes, thank you. This is Megan Sway. I'm Policy Counsel with the ACLU of Maine. Good morning. So yes, Major Groton and I talked about this with the attorney from Maine State Police, and our position, I think we're both in similar positions where we both feel strongly enough not to back down, but also don't feel strongly enough to risk it all to push this. So our position is that if we went with the bill as written, just repealing 807, we would join 48 other states in the federal government who don't have this in their statute. So there's no federal statute, there's no state statute in 40 other states, and they all seem to be functioning just fine. If we did put this in statute, we would join Indiana as the only other state that puts these factors into law. And I understand the idea of wanting clarity and wanting people to have a rubric, but I also think that if 48 other states and the federal government can do this without putting those rubrics in, that it's just not necessary. In terms of the appeals process, I have to go back and look, but I'm pretty I mean, right now, if we don't get a FOA response at the ACLU that we are comfortable with, we go through the court process to have a court intervene. And so I don't know that this process that's proposed is necessary, but it is sort of a fast track. And so, we don't oppose it. Obviously, we like access to courts. We like being able to challenge quickly things that we think are not legal, but we just don't think that this is necessary. And that it's just much cleaner to just repeal the section and join 48 other states in the federal government.
Thank you. I agree with you, but this amendment, for me, for the layperson, clearly spells it out, though, and including the appeal process. So, Representative Groton. Excuse me, Major Groton. I just made you a representative. I'm sorry about that.
Well, thank you very much. I'll look for my nameplate the next time we can all be in the committee room together. Thank you very much, Senator. I appreciate the chance. I did want to clarify one thing. Our staff attorney called me and asked that I clarify something. Really, what this amendment also does is not only reflect the language in 804 in the spirit of federal case law as we all understand it, but that this also would preserve that opportunity for law enforcement to use the language at times where we would neither confirm the existence or non-existence of a particular piece of information. So that would preserve our ability to use that language. And maybe if I can give you an example, that might be helpful. If our computer crimes unit uses a piece of technology to track somebody exploiting and trafficking children, and they're using certain XYZ technology to do this work. If we received a request regarding whether or not we use this specific technology, if we are answering that question and we're now telling a potential suspect that yes, they may be using this technology, that's going to allow that person to avoid detection, and that doesn't help us stop crime. So this amendment would allow us to neither confirm or deny that we're using that technology. We would be saying we would not confirm whether or not that technology is used by the state police or whether we've acquired that technology if that fits under the 804 exceptions. So this would preserve our ability to use that language. And this is why we wanted to bring this forward so that the committee clearly understands that if in the future that set of facts and circumstances occurs and our response is that we can neither confirm or deny, if we use that language, I do not want the committee to feel like, well, here, the state police, we passed this bill, the state police are still doing this. We all understand that 804 still provides opportunities, and in our discussions with the ACLU, I believe we all agree that there will be times that is going to be an appropriate response, that can't be released. But this would preserve our ability to use that language in those circumstances. So just for clarity, I wanted the committee to understand that because we value our relationship and we want it to be really clear. We believe this amendment would not only help clarify it for the committee, but historically, they would provide clear guidance to the reader of statutes or the person who receives that response. So that is our goal, is to be clear and transparent about our decision-making.
Thank you, Major Groton. Anyone else? Major Groton, do you wish to speak? Or anybody? Megan Sway, go right ahead.
Sorry, I just wanted to clarify that yes, that the state police would not lose that ability to use a GLOMAR response if you just repealed it. It's not as though they only have the option to hide investigative techniques if it's written down in statute that way. The ACLU agrees there are times when neither, not confirming or denying is the appropriate response, but it should be narrowly tailored. And there's a ton of case law across the country that really helps shape what that is. And that case law is really clear that in the example that Major Groton gave, they would have the right to withhold that information. And so I just wanted to clarify that you don't need the language in order to still, for them to preserve that right to make that response.
Representative Morales?
Thank you very much, Madam Chair. Just wondering, because I do tend to agree. I used to be the Freedom of Access Act officer for the Maine Department of Transportation. And so I know robustly through that particular statute and the responsibilities of the department. I also know the exceptions. And I'm wondering, Major Groton, did you run this by the Ombudsman for the advisory for Freedom of Access Act? Was there any discussion around that? Because I also think we've heard a lot in this committee around, we don't want to do anything superfluous, right? There's no need to add to our code when something already exists and when protections already exist. And so all of the suggestions that you made for how we can protect, use of technology and all of that when it's an investigation and public safety is an issue, are protected under our Freedom of Access Act currently. And so I don't see a need to add that just for clarity when it's already existing. So my question, I guess, I'm sorry, just to go back is were you able to run this by our FOA Ombudsman for the state of Maine?
I have not done that. Literally, we had a meeting yesterday and some discussions and a flurry of emails into the evening last night between our staff attorney and Megan. So I have not done that. I don't believe that we have talked with them about this particular amendment. Back when the committee heard the bill, there may have been some discussions possibly. Again, I think Megan really encapsulated our mutual opinion, I believe, in that passing the bill is fine as written, but again, our concern, and really we wanted to get the discussion out there. So I had told Representative Warren yesterday that it was important. I think that the committee all hear that there will be times that we may need to use that language. There still will be times when information cannot and should not be released. And we wanted to make sure that we're being particularly clear with the committee in that regard. So I certainly appreciate the opinion that we could still use that language. When you read 804, it doesn't necessarily make that particularly clear. It doesn't mean that we can't use it, but our goal was to make that abundantly clear so that nobody's surprised when they see that. 804 does delineate the circumstances under which we would not be releasing that information, but it isn't particularly clear in a quick read as I'm looking at this on screen that Glomar language, if you will, is appropriate. So when we use it, we just don't want anyone taken by surprise. We don't want anyone to feel like we're not being transparent. And we hope that folks remember this discussion, the committee's discussion surrounding that.
Great, thank you.
Want to respond? I wanted to respond to what Representative Morales says. I agree with her that if you're involved in an occupation or responsibility where you have to know about Freedom of Information Act and ombudsmen and attorneys and what have you, I said it before and I'll say it again. Rather that this is an overkill or not, for a layperson reading it, it's much clearer than having to know everything about the Freedom of Information Act. That's how I feel. And whenever I read a bill, I don't want to cross-reference or have to look for someone who's well-versed in that. So it sounds like an overkill, but I would rather see it in one place, is my personal opinion.
Thank you. Do you have a request for me to rejoin the meeting? Could you let me in? Thank you.
We began after you left. Major Groton mentioned that you, both of you had a conversation He drafted this up. He did say that he did not know your position on that. So if you wish to make that known, go ahead.
Thank you, Madam Chair, and thank you, Major Groton. I appreciate that. And yes, Major Groton and I did speak about this yesterday, and we both share the opinion that we want everyone to understand that although the bill does aim to remove the GLOMAR provision, and I don't support the amendment, I would like to just have the removal, that both of us, Major Groton and I, agree that we want folks to understand that that doesn't mean that the state police might need to, at some point in the future, based on established case law, say, I'm sorry, I can't answer that question. But what this will do, what the proposal as written does is it has Maine join 48 other states and the federal government in relying on established case law as police respond when they're asked these questions. So said another way, and you may have already heard this in the discussion, I apologize if I'm repeating, Maine is one of only 2 states that has this provision in their state law. This proposal simply removes it, has Maine join 48 other states and the federal government relying on case law. That does not mean they won't ever say, I can't answer that question, either because it interferes in an investigation, et cetera, I'm sure you've already heard. So that's my position on the bill. I would like a straight up ought to pass on this bill without the amendment.
Representative Morales, you had your hand up.
Yes, thank you. I make a motion ought to pass LD 2139.
It's been moved and seconded to pass. Now that we've got a motion out. Oops, didn't see. I'm looking far. I should be looking right here. I'm sorry, Mr. Parr. You wish to speak, and please identify yourself.
Yes, thank you very much. Can you hear me okay?
Yes.
You can. Okay, great. Yeah, my name is Chris Parr. I'm the staff attorney for the Maine State Police. I did work with Megan and the ACLU of Maine on this amendment over the past few days. I just wanted to clarify a couple of things. First, Section 804 right now is the statute that law enforcement agencies such as ours do rely on when we receive a FOIA request for example, police reports. And that statute basically, if certain harms would result if we disclose the record, so we would acknowledge, yes, we have this record, but we can't disclose it to you because of these reasons. And those reasons are listed in Section 804. Okay, so 804 says that intelligence and investigative record information, and I'm just going to call it police reports to make it easy, that police reports are confidential under law and therefore not public records by definitions, and that their restriction, that their dissemination publicly is restricted if certain harms, 12 harms that are listed out in statute would result from their release. Okay, so one of those harms, for example, if there's an unwarranted invasion of personal privacy, or another example is if release of the information would compromise the ability to impanel an impartial jury. And yet another example is if release of the records would compromise a pending law enforcement investigation. What 807 and what the amendment does is it says, it's not saying that we are repeating what we can already do in 804. what it's doing is saying that in what current 807 as draft, what's in statute already currently allows, and what 807 would a proposed amendment would allow, is that in certain circumstances we would be unable, as the major explained, to even confirm the existence or non-existence of certain records. And it's very easy for me to think where if someone has been accused of something and the investigation found that they were exonerated through the police investigation, and therefore nothing ever became public. And say someone later, a potential employer, were to call our agency and say, hey, I'm doing a background check, I want to possibly hire this person. Do you have any records about this person of investigation? If under 807 and under this amendment, if saying, yes, we do have records, or if 807 were repealed and 807A did not go into effect, we, as a statutory matter, would be left with having to say, yeah, we have records about this person, but we can't give them to you because they're confidential. What 807 currently allows us to do, and what 807A, what's before you, would continue to allow us to do, is say, yeah, we can't really confirm the existence or non-existence of those types of records. And that's really an appropriate sort of response, because by confirming their existence to someone, especially if they were exonerated through an investigation, by confirming them, it puts them in a bad light, potentially harms them reputationally, and in that example might cause them to be unable to get the job that they were trying to get. Another example, and I'll try to be brief, is if someone makes, if a victim of domestic violence, for example, were to contact our agency and we make record of that, but they're concerned about their safety and they want us to not tell anyone that they've contacted us, then we'd be able to say, give a similar GLOMAR response. We're not going to confirm or deny the existence of records. And that's a matter of trying to ensure for the safety of that person. And the other example that the major gave is yet another good example of what the proposed amendment would do. So 804 is an extremely important statute, but 807A would allow us to really, in these now limited circumstances that have been proposed, to still be able to give that GLOMAR response. Now, 807 could go away altogether, as it sounds like you're about to vote on, and I understand that. And I guess what the major and I were most concerned with is that the legislature knows that we're very open that there will be circumstances that it's not hard for me to imagine where we will need to issue the GLOMAR response in response to a request in order to protect someone's safety, or in order to protect someone's privacy, or in order to protect a specific type of investigative tool that we're using. And so I just want to make sure that we just wanted to make sure that if you do vote to remove 807, if that's your choice, that we will still need to rely on what would now be case law to make that response. And finally, the thing about having a statute is that the statute does provide some guidance as to the circumstances under which GLOMAR response would be appropriate for law enforcement agencies. If you remove 807, one of the things about that, and it's really a public policy consideration more than anything else, is that it's really going to leave people having to litigate this and go to court and start having case law developed in Maine to establish, the propriety of the GLOMAR responses that are used. And that obviously is going to mean that residents of Maine who are going to have to, have the resources and expend the resources in order to go to court and sue the Maine State Police or any other law enforcement agency about this so that it can be decided. Having a statute hopefully would avoid that sort of need to resort to that litigation. But at the end of the day, again, we just wanted to be clear as to what we would anticipate would be the need to use this response if the statute's repealed. And I feel like we've been clear, we've been as transparent as we can about that at this point. So I appreciate the opportunity to talk. Thank you.
Megan, there you are. Go ahead.
I just wanted to clarify just a little bit, because I am very sensitive to this idea that we don't want to encourage litigation. But no matter which way you go, whether you repeal 807 entirely or you replace it with this amendment, there will be litigation if people want to challenge, because there's been a prohibition for years now on the ability to say anything. So there is no case law, because Maine State Police was barred by law from responding for years. So it wasn't litigated because it was in court. It was just a flat denial. So regardless of which way you go, there's a risk of litigation. And I would just hate for this committee to think that putting everything in statute laid out means there's no risk of litigation. And I think that the case law across the country is pretty uniform and pretty clear. So the chances of litigation are, this, to me, almost the same whether or not you do this. So I just wanted to make that clear, because I would hate for the committee to think that we were advocating for something that we thought was going to cost the state of Maine a lot of money.
Representative Morales.
Thank you, Madam Chair. I've just been going back as Attorney Parr was speaking and just going and analyzing 804 based on the scenarios that he was discussing. And what I really see is number one, 804, 1, 7, and 8 provide the protections that the Maine State Police may need. Number one is that they do not have to disseminate intelligence and investigative record information when it interferes with a criminal law enforcement proceeding. Number 7 is they don't have to disclose, and this is exactly the language, investigative techniques or security plan. And that, Attorney Parr was talking about maybe not wanting to disclose a specific type of investigative tool. And I just wrote that down as he said that. And I would characterize that as investigative techniques. And number 8 is endanger law enforcement officers or others. So that's sort of the DV example is, if disclosing any material would put a life at risk, that squarely falls within that particular exception. And I've been thinking a lot about the employment law issue that he raised as well. And I know background checks are regularly conducted for $35 by employers, by housing, all things. It's sort of something that's standardly done to figure that out. But I don't think that would even apply under this proposed amendment, because having to disclose a charge for an employer, because this amendment only would apply if there was a reasonable possibility of interference with law enforcement, endangered life safety, physical safety, invasion of privacy, specific investigatory techniques. So I'm just trying to really understand where that is coming from. And I think that 804 really provides the protection that the state police need and want, and makes it consistent with the other 48 states in the nation. So I just wanted to put that on the record. Thank you.
Representative Cooper.
Thank you, Madam Chair. So does 804 basically track FOIA?
Would you repeat that question? I missed that too.
I wanted to know whether there's really much difference between the the listing of situations where you can refuse to disclose and the same provisions in our state FOIA Act. And I'm asking Representative Morales, since she's the expert at this. Representative Morales, can you?
I could answer, and then if anyone else wants to chime in, FOA makes exceptions in Title I, and if there's a statutory exception to disclosing the information, the recorded information, then you would go to that specific statute, and then here we have that specific statute that specifically enumerates what would be an exception to disclosure. That's how I would understand that. So FOA doesn't have this level of detail that's in 804, but it refers to whether there are other statutory exceptions within our code.
Mr. Potter, yes?
Yeah, I just wanted to, I can answer that. I've been FOA officer at my own agency for over 14 and a half years, just 14 and a half years or so. So I'm very familiar with this too. So FOA does have in section Title I, section 402, 3A, and one of the exceptions to the definition of public records are records that are designated confidential by statute. Police records, such as the kind we're talking about when we talk about intelligence and investigative record information, are exactly those types of records that are designated confidential. So it is an exception to it's a express exception under the FOA statute as to what is a public record. I agree, Megan is exactly right, and I'm glad she said what she said. By putting something in the statute, litigation is going to probably result in either case. She's absolutely right, and so I want to reiterate what her point was, because I think that's correct. The last thing is that here's the distinction between 804 and what 807 allows. Take for example 804 subsection 1, which says that we cannot disclose records if doing so would compromise basically a law enforcement investigation. So this would be, that's saying you can't disclose the records. But what it doesn't say is that you not only can you not disclose the records, you can't confirm their existence or non-existence. That's what the purpose of 807 is and what the purpose of the amendment would be. So here's an example. Say someone is a drug trafficker, and they wanted to know, well, does the Maine State Police have an investigation going on of me? Am I on the Maine State Police's radar? Under 804, the person might make a FOA request and say, any and all records you have about me relating to, well, just say that's the request. 804 would say, has it that we wouldn't be able to disclose the records, but we'd have to say, yeah, we have the records, but they're confidential. We can't disclose it. And at that point, you would have revealed that to the person making the request that, oh, wait a second, they have records on me. They must be investigating me for this unlawful activity I'm engaged in. What 807 currently allows us to do, and what 807A would still allow us to do, is say we can't confirm or deny the existence of those records. And at that point, a person wanting to find out whether or not law enforcement is investigating their unlawful activities would be unable to learn that. And so that's one of the reasons why it is important. And that is the distinction, is that 804 goes to dissemination and disclosure of the records. 804 does. 807 goes to whether or not the existence of the records would even be confirmed. But that said, I hope that's helpful. And again, if 807 were to go away and the amendment weren't to pass, if someone were to make that type of inquiry, we would, in all likelihood, give a GLOMAR response and rely on the case law and litigate the matter. So it really is, I think the ACLU of Maine and the state police are kind of pretty close on this, regardless of which way it goes. Thank you very much.
Representative Warren.
Thank you, Mr. Parr. You brought me to the question that I was going to ask, because I was starting to think that maybe I misunderstood Major Groton. When we spoke yesterday, I felt like we had an understanding that we didn't really need the amendment and that we were just going to make sure that people knew that this would sometimes still be used. And I'm sorry to be so bold. It's one of my maybe bad habits, but it seems like you're really defending the amendment a lot. So I'm trying to get the sense of, are we okay with the state police joining 48 other states and the federal government in removing the GLOMAR provision, which is what I thought Major Groton and I left our conversation yesterday with an understanding of. What I hear you saying is we really need this other amendment. So I'm just trying to get some clarification.
Yeah, I'm happy to respond to that. No, Major Groton is exactly right in what he told you and what he had said earlier today. I'm just trying to explain what the reasoning was for the amendment and sort of give it that context. At the end of the day, though, it is the sort of thing where I think the thing that was most important, as the major said, is that we were just clear that this type of response might be an appropriate one to give, and that we'd be relying on that case law that's been discussed about it. So at the end of the day, Major Groton, I think, has spoken correctly.
Anyone else wish to weigh in on this?
Hi, yeah, and again, just sort of researching as Attorney Parr is talking, but it looks here like in Title 16, specifically to that criminal history record information, Title 16, Section 705 of Maine law currently allows a GLOMAR response of a person's criminal history record information. So I believe there's still coverage for that particular issue that Attorney Parr raises. Title 16, Section 705. And again, I just point to 804, Section 7, discusses the exception for disclosing investigatory techniques or security plans. So those are the specific types of investigative tools that the police may be using. That certainly could be an argument they make to not disclose because it's of a safety concern and an investigation.
Have a motion on the floor? Yes, we do. Oh, Mr. Parr.
Yeah, just very quickly. The section that Representative Morales was just talking about applies to criminal history record information. That's different from intelligence and investigative record information. So it's a completely different chapter. So I just want to make sure that that was clear. There still would be a GLOMAR type of response about someone's criminal history record, but that's not investigative information that's talking about. So thank you.
I don't see any hands up on any other questions. Are we ready to take a vote on this? Okay, would someone please repeat, Representative Morales, the motion is ought not to pass? Ought to pass, excuse me. Ought to pass. Okay. Go right ahead.
Thank you. Before I call the roll, I could not hear who seconded on the Zoom. Thank you. Okay. Representative Cooper.
Aye.
Representative Cooper, aye. Representative BB Center.
Yes.
Representative BB Center, yes. Representative Warren.
Yes.
Representative Warren, yes. Senator DeChambeau.
No.
Senator DeChambeau, no. Senator Carpenter.
No.
Senator Carpenter, no. Representative Carney.
No.
Representative Carney, no. Representative Morales.
Yes.
Representative Morales, yes.
Thank you. Thank you all for that.
Senator, I'm sorry, Jane, again. And
Yes.
the people who voted no, I need to know what they want.
I will speak for myself if the others wish to. I would propose the amendment. All three with the amendment.
Okay, thank you.
Thank you. If there's no other matter to bring up, this concludes this three bills for today. The next time we meet will be on the 17th, and that's LD 2151 and LD 1756. And that is it for Friday. We come back on Monday, the 20th, and we'll go over those bills on Friday. If there's nothing else, Representative Cooper?
Thank you, Madam Chair. What time do we begin?
I believe 10 o'clock again.
Okay.
Okay. Hearing nothing, this concludes today's meeting. Adjourn. Thank you.